Are we ready to start, everyone? Are we ready? Maybe we can start in like 15 seconds.
I think we can start. So before we start, one important thing for this is address coaches. Please text the organizers the list of teams that you're scheduled to plead against in Vienna. You do know the list, the 4 teams. Please communicate them to avoid any potential conflict. Well, because I believe we do have a conflict. At the moment, one of the 2 teams that are here have a conflict of interest, so you cannot plead against these teams, neither in practice rounds nor in the general rounds of the pre-moot. So please the coaches make sure to send the list of teams.
Okay. I think this is the most important 30 or 40 minutes that we will be discussing throughout the pre-moot, at least in my view. So I think when it comes to the oral pleadings, please note that maybe you have the best arguments, but if you don't know how to say them in the right way and how to avoid some of the struggles when it comes to the arbitrators, you might lose a lot of scores that might just end up losing a lot of scores, which means that you will not be qualifying either, whether it's in the pre-moot or in Vienna. So I think what we can do briefly is to say the most important things, and then we can open like if there are any questions that you might have. So first of all, when it comes to the introduction, let's always forget something called university. So you're not representing any university. So when you're saying your name, you represent yourself, and then you're saying you are, whether you claim to respondent, the name of the company, and then the time allocation, which is how many minutes are you planning on having while you're pleading. Usually it's the 14-minute rule, so 14 minutes for each pleader, and then you're leaving 1 minute for the rebuttal and for the rebuttal. And then there is after the introduction of you and your co-counsel, it's very important to give the roadmap. What is the roadmap? It's the 2 big submissions that you are dealing with. And then after giving the 2 big submissions, now you delve into the first submission. Now there are 2 opinions. First one, do you give another roadmap for your first submission, or do you just start saying the argument itself? So there are advantages and disadvantages for doing both. when it comes to the advantages of doing the roadmap or the detailed roadmap for the first submission, you will look good if you finish them all, and you are like well prepared and you are well organized and so on. But the downside of it is that sometimes you will be asked a lot of questions that you might not be able to finish all of the subpoints that you already said that you will be dealing with. So when it comes to this point, sometimes, for example, when we talk about issue 3, so we have 3-4 subpoints under issue 3 or the requirements. You as claimant, and correct me if I'm wrong, you don't have to show that all of them are you don't have to show that all of them are met, unlike respondent. So sometimes if you're running out of time, you can just skip the last part, for example, and move on to the next point. But if you tell me when you first started your argument that I will be dealing with 4 subpoints, all of the tribunal, they will write it down, and then eventually when it comes to the feedback, they will ask you that you did not follow what you said. So it's for me, I don't know about you, Ghada. For me, I think that what we need to do definitely is the roadmap, the initial roadmap for the 2 big submissions, and then especially for the second submission, I wouldn't give a roadmap unless we have 5-6 minutes and we are sure that that the detailed roadmap is going to be done within our speech.
I personally prefer the sub signposting, so the second roadmap. But you need to make it if you don't have sufficient time. And for example, you're in a position where you don't really need to prove that all the requirements are met or not met. You should cite them, but you should also mention that in the interest of time, and since the arguments are cumulative or something, that we only need to prove one, and for the interest of time, we'll be discussing this extensively. So, but up signposting, I think it's important because, yes, maybe you don't have sufficient time to argue all the arguments, but at least the tribunal has an idea about what you would have argued if you had sufficient time. I mean, you don't need to do signposting if you're moving to your second submission, but for the first submission, potentially you don't know if it's a tribunal that would ask a lot of questions or too little questions. But you should also keep that in mind, I would say, when you're doing the roadmaps.
Another thing is that for the argument itself, please note to everyone that the questions of the arbitrators from the arbitrators are way more important than the argument itself. So a lot of people will be like, they would be very, very angry if the arbitrator or the arbitrators are asking many questions because they couldn't finish their full arguments. And then they will show this to the tribunal. The moment that the tribunal or an arbitrator will see that you're not happy with this, they might not ask a question, but it will be shown in your grading. So always show that you're confident, show that you're happy with the questions, and it's okay to ask for more. Definitely don't ask them to ask you questions, but sometimes the way that you give an answer shows whether you are just trying to finish your argument and just move on, or you're ready to answer. Because as I said, everyone can have a ready script, and then like the best script, you have a lot of memos that you can just go and pick the best arguments, but not everyone have the capability of answering the questions from the tribunal. So I think this is one of the worst things that anyone might do, is that to show that they're not happy with the questions, or they're just believe that the questions are taken from their time. Always the questions are way more important than your arguments. And we saw this in a lot of deliberations with the tribunal in the BIS and other competitions. So it's always important to be comfortable with the questions. Now, how to deal with the questions? I think this is like the most important point. We have a lot of questions from the tribunal, and we have a lot of tribunals. So there are tribunals or arbitrators who are just coming to put like a tick mark that they attended certain moot or whatever. So they don't necessarily like they didn't maybe read the case or to know what's happening. They're a lawyer, a partner in X law firm, and they're just coming to Vienna every year. So sometimes their questions are not related to the case, but with that you should answer them. And some questions are irrelevant. Some questions are related to the laws, to the facts. So you should be prepared to answer all of those questions. There are a lot of ways to avoid some weird questions. And one of them is always, if you don't get to know the answer, try always to rephrase the question or ask for a rephrasal. So the best thing, as I think today we did it, or Jan Paulsen did it a lot of times, is that if you don't know the question, or you knew the question but you don't want to answer that specific question, ask the tribunal. For example, if I understood your question correctly, you mean 1, 2, 3, and then you put the question, the phrase that you want to answer it. Mostly they will say, yeah, sure, why not? I answer this question. So, and if you don't know the question, or you're not sure that this is the right question, please don't answer it just by what you think. If you're not sure, always ask the tribunal to repeat that question or to rephrase it. So answering the questions is the key to have a good score. Any addition?
The type of questions that you might receive from a tribunal are threefold. Either factual questions, so basically the answer is in the record. You need to know your record by heart. Page, line, paragraph, word by word. There is legal questions, so you know the law or you don't. The legal requirements of each and every single provision you're using, you'd need to know them by heart. And the third option is what lawyers usually and practitioners tend to ask, hypotheticals. They're asking, what would your client do? Or they are suggesting things and asking if your client would accept or not. For the first two types of questions, it's more about your preparation, knowing the record, knowing the law. For the third type of questions, remember, you're neither claimant nor respondent. You're a counsel on the case. You're representing the parties. You're here to represent them on particular legal questions, and your authority does not extend to these hypotheticals. So the first thing you need to say that you need to refer back to your client. However, you do add the however, and you give a potential answer that maybe potentially your client would be inclined to do a certain thing. But it's not a firm answer because you're not in a position to say. Always remember that. If any arbitrator is suggesting options, they're not, it's not your decision. It's your client's decision. You need to go back to your client and ask whether they will be willing or not.
Another hypothetical is that sometimes they might ask you, let's assume that this happened, which is not in the case. And then they might, for example, let's assume that there is a CISG issue, and then you're asking for damages. So the tribe might ask, okay, counsel, let's assume that the CIC does not apply. Would you still get the damages? So it's okay to say no, even if your primary argument is a yes, because it's a hypothetical question. You say, although we still believe that the CIC is applicable. However, if the CIC will not be applicable, we might lose the case. So it's okay to concede if it's a hypothetical, and some tribunals like that, and a lot of tribunals wouldn't like a stubborn counsel that just says, well, whether we apply this or that, we still have the case. So be careful when it comes to the hypotheticals, and always read the tribunal. And you should an important fact that we should already said is that you should always know who is arbitrating your team. So when it comes to the pre-moot or to the vis-moot, they will send you who are the arbitrators, and you should check whether they're practitioners. Is this their first year in the vis-moot? Are they coaches? Because it differs. If they're coaches, it means that they know the case file very well. If they're just practitioners, like a partner in law firm, it means that they will mostly focus on the theoretical side and maybe just general legal questions. So it all differs, and this actually matters. And while you are in the session itself, I mean, the luckiest person is probably the third and the fourth pleader, because you get to know the tribunal, and you get to know whether they ask a lot of questions or they just let it go. Are they lenient when it comes to giving or adding more minutes, or they're more strict? However, please note that if you're the third or fourth pleader, mostly as we're having now, it's too late, and probably they just want to rest and to have their energy is zero, and you need to catch their attention, and your tone, your voice, the way that you speak is very important. Do we have any questions so far? Do we have anyone from here who played last year? So a lot of people that, okay. Tamam.
On that note, keep in mind that your arbitrators in Vienna will also receive your memos, and they will read. Some of them would read them. Some of them would even print them and bring them to the room and ask you about stuff you wrote in your memo. So keep that in mind. My team last year had that particular experience. They were like, but you wrote this in your memo. And he brought the memo with him. So that is possible. So remember what you wrote in your memo as well, and be ready to answer these kind of questions.
But this does not mean that you should stick to what you
Yes.
said, but you should have an answer that, okay, although we wrote this, however, now it's claimant's position or whatever. Okay, so the time management, I think it's one of the most important elements. So as we said, you will ask for 14 minutes. You have 3 arbitrators. I'm sure that always one of them will have the time matter, like they will take it very seriously when it comes to the time. So if you said 14 minutes, first you must address both submissions, because even if you finish the first one like perfectly, and you didn't have the chance to move on to the second one, I don't think that you will be graded more than 70 maybe, or 70. So I think some might just skip 50, but it's
50 is the lowest score you could get.
Yes.
You literally graded from 50 to 100, and you could get 55, I think. Well, that depends. Okay, that's what we call a hot tribunal. If they keep asking you questions and you gave signs that you want to move to your second submission on multiple occasions, but they still want to answers to their questions, their questions are your top priority. As long as you made it very clear that you're aware of your time. I see that I'm running out of time. Members of this tribunal, I see that I'm running out of time. I would like to move to my second submission, or in the interest of time, I would like to move to my second submission. And sometimes they would stop you. They'd be like, but could you please answer this, this, and that? Their questions are your top priority. As long as you gave signs that you're aware that you would like to move to your second submission, it's fine.
But I mean, and usually you will ask for that on minute 8, 9 maximum. So even if they insist on having you answering that question, I don't think that it will happen that they will keep asking for 5 minutes. So this is your duty as a pleader to make sure that minute 7 or 8, khalas, this is my deadline. That even if they ask, I'll say, thank you for your question. If I may answer this question briefly and move on to my next submission. And then they will ask another question. I would say the same thing. I say that I'm running. So you keep telling them, because they will, at the end, they'll deliberate. And then, although one might say, but she didn't finish the first submission, I'm sure that the other two will say, well, because of our questions. But if you wait until minute 12 and then you say it, it means that you have a problem with the time, like the time that you allocated for each issue. So it's always, there is a soft deadline. Like, let's say, for example, you made it 7/7. So this is the sub deadline, and this is your co-counsel's duty to let you know about the time, because sometimes people are nervous when it comes to pleading, so they might not look at the time or anything. So your co-counsel should tell you that, okay, minute 6, minute 7, move on, and then they if they don't look at you or anything, they should have a sign. And my co-counsel was kicking me when I had like minute 8 or 9 because I wasn't looking directly at the timer. So I mean, we should always let the tribunal know about our situation, and yeah, finishing within the time is very important. So this is from moving to the first submission to the second submission. But there is also an important thing is that when you ask for 14 minutes, you should stick to the 14 minutes. Okay, so when it's minute 13, you should know whether you will be able to finish within the next 45 seconds or no. If you are able to finish that, always make sure to try to conclude in an early way, like 13:20, 13:30. خلاص, you started your conclusion. If you think, no, I'm not able, or I will definitely need an additional minute or two, always ask early, because we saw a lot of arbitrators who would reject the additional minutes. So if you ask them 13:50, may I ask an additional minute? They say, no, counsel, conclude. You will have like 5 seconds to finish your argument and to conclude. Okay, so it's always the best time is from 13 to minute 13 to minute 13 and 30 to ask whether you can have an additional minute or two, and always tell or ask the tribunal, why are you asking for those 2 minutes? So, or 1 minute, for example, are you asking it for answering the question because there was a last minute question? Or are you answering the question and you're concluding? Do you want to finish your submission? And if you say, I will answer the question and that's it, and then you answer the question and then say additionally, and then you say, and no, this is not acceptable. You should always stick to what you said to the tribunal. And it's always, it's better to not ask for minutes if you can, because the perfect thing is to finish within the 14. No harm of asking any questions, and there will be no deduction of marks if you ask, but I'm sure that there will be a bonus if you finish within the 14, especially if you get to finish within the 14 with answering the questions and everything. But always give the tribunal chance to assess whether you are eligible for that 1 minute or not. Another thing is that if you are, for example, respondent in the merit section, you should always look at whether the tribunal gave an additional minute or two to your opposing counsel or no. Because a lot of tribunals would only give you an additional minute or two if they give your opposing counsel, because of the fairness and so on. So they don't want to give 14 minutes to claimant and then 15 minutes to respondent. So you should know, or you should have this probability that they might reject your additional minute because they only gave claimant 14. So and always be careful with the instructions. So a lot of tribunals might tell you from the start, for your respondent on the merit section and your opposing counsel ask for additional minute. So sometimes, I wouldn't say always, but sometimes they will ask, okay, counsel, you have 15 minutes from now. However, no additional second will be given. خلاص, it means that just for fairness, they get. So a lot of usual mistakes is that a person, when it comes to minute 14 or 13, can I ask for an additional minute? No, you don't ask for that because it was already granted initially. So always be careful with the instructions, because a lot of arbitrators will tell you what went wrong with your pleading, and you don't want some formal mistake affect your gradings. I think when for me, I think that the last part that we might discuss is how to cite the problem and about the sources. So first, I think when it comes to doing the referrals to the case, do you agree, Ghada, it's page number, and then you're saying what is that page? So for example, page 13, the contract, and because while you're saying page 13, I should move to page 13, and until then you're telling me what is this exhibit? Is it a contract? Is it a witness statement? PO? What was it? So page 13, contract, and then you're taking the specific part, clause 15, second line, third line, or whatever. I think for me this is the best part. For me, I don't have, or I don't think that saying whether it's C1 or C2 is relevant. except if you want to show the tribunal that this is actually, for example, an exhibit from like respondent or claimant. But for example, the contract, it's not actually claimant's exhibit. Yes, it is under their exhibit, but it's not something that it's only for claimant that they did it, because it's a mutual thing. But since they started the case, that's why they had it one of the exhibits. And you will see always respondent referring to, for example, C1 or C2 for the contract, because they don't have to do it again. When it comes to cases, to case law or to scholarly opinion, it's always important to give the relevant information for the case law. For example, English High Court, whether it's the first instance or the High Court, whether it's Court of Appeal, whether it's an award or no. What year was it? And if it was 1920 or 1930, there is a chance that there might be an overruling on that award or judgment. So this is an important factor. The applicable laws, for example, if you're talking about the CISG, it's always important to tell the tribunal that this is a CISG case. It's not, for example, they're using some like the Saudi law, for example, because they will say it's not relevant. Why do you bring something from another country? And other relevant information. When it comes to choosing your cases, it's always important to choose the cases based on the similarities and differences. So, for example, if I'm using a case, I will try my best to have what is similar from that case to my case and tell it to the tribunal. And if I'm defending, I'll take the same case and to show it shouldn't be applicable or taken into consideration because the differences that we have in that case. Any questions or concerns or addition from our previous pleaders, please?
Obviously, if it's a landmark, a very, very famous case, and the presiding or the expert on that case is of relevance. Last year's case, the expert on a particular case was Professor Schwenzer. So it was very important to mention that the most relevant authority was actually an expert on that case. So yes, you need to know not only if the tribunal or the expert is of relevance, but any similarity and any differences in facts and in the applicability of the law with our case. They will ask you to which extent are they similar, to which extent are they different. You should prepare for all the cases you're using, because potentially opposing counsel might choose that case and you will have the counter argument ready that in fact this was different from this. This is where it differs. That's why we cannot rely on that case.
Last point is you are sitting in front of 3 arbitrators. Common mistake is that someone would just look at the presiding arbitrator and leave the other 2. So this is going to be a disaster for the grading, because they will think that they are not as important as the presiding. And honestly speaking, practically speaking, the presiding, there is no difference between the presiding and the co-arbitrators. They all have 1 vote. So they are all the same, but the presiding is only there for controlling or doing the admin work for the session itself and controlling who's going first and second and how things are done. But they are all the same importance. So don't look at any of them in specific and just share the eye contact. However, if someone asks you a question, and even when you address the tribunal, you always say members of the tribunal. You don't say Mr. Presiding or Madam Presiding. Another thing is that if the presiding would ask a question, you might want to say Mr. Presiding or Madam Presiding, then you answer. But never say Mr. or Madam Presiding all the time, because you're only addressing that argument to him or to her. Any additions?
Okay, rebuttals and surrebuttals. Okay. The starting point is the rebuttal. The most important thing, it should be short and concise. There are divergent opinions on the content of the rebuttal. For example, should you use a new case that you haven't used? Some think it's a good idea. Some arbitrators think it's a bad idea, like referring to a case in your rebuttal. I say it depends. How long should the rebuttal be? For me, it's 30 seconds. The shorter, the crispier, the better. If you drag it a bit, it would lose its purpose. It has to be a mic drop. And it has to stem from what opposing counsel just said. So if you're going first claimant and respondent is in the responsive position, your job during the 14 minutes that he's pleading is for you to take notes of more than one rebuttal. And then when it's time for you to do your rebuttal, you need to pick the strongest out of everything you just taken note of. It has to be an answer or you're like picking on something they said, not add a new argument. You will be sanctioned if you add something new that has no relevance to what you discussed or what opposing counsel discussed. Now, coming to the sir rebuttal, the person who's supposed to respond to the rebuttal. Well, you don't really have a lot. You cannot add something irrelevant or bring up a new idea. You have to respond to the rebuttal. You cannot bring a new idea that has no relevance to the 30 seconds that opposing counsel just spent. It has to be a response. You don't always need to make a rebuttal. Sometimes you have an opposing counsel who said nothing, that whatever they said is irrelevant. And the tribunal is very well aware of that. You can rest on your submission. There is nothing wrong. It could be more impactful to say that a lot of what has been discussed, we rest in our submission. That could be more impactful than saying whatever.
One addition, for example, when we say cases, new cases, as Agatha said, so always know that if you bring a new case, for me, I think that your opposing counsel can also bring in another case. And since it's not binding, what's the point of saying something that is not binding that I can bring another case? And there is no case that will just end the dispute, right? So it's always important to say something, the weakest point that they said, and always try to focus on the points that the arbitrators focused on. So you will always find that the tribunal were not convinced with one of the arguments. Try to pick that point and avoid saying like a big topic. So for example, you talked for 5 minutes about the intentions, and then your rebuttal is also about, but they never intended to do this. It doesn't make any sense, because they will just say, well, we also discussed for 5 minutes. It's either a factual mistake or a legal mistake, or a point that the arbitrators just said and they were not convinced with a certain point. But don't give any point that was already discussed. So if the tribunal asked a question and then they said, I don't have the answer, it's not ideal to say the same thing, because the answer will be the same, and the tribunal would say, you just took what I said and just took it again. So again, and the shorter the better, because also if you take like the full minute, I will be able to focus, to put everything together, and then I have like plenty of time to say it. If you say it in 10 seconds, I will not have much time to think of an answer. Yeah. I mean, first of all, Malik, I think there is an important thing that we should know, that it's not a question. So the rebuttals, it's a statement. Yeah, but I mean, for me, I don't think that there is an issue if you want to say something differently, but the same topic. I think this is like a strong point. But yeah, I mean, and another point is that always, I mean, we saw a lot of teams or like pleaders, they will ask question to the opposing counsel. The rebuttals is a statement. It's not a question. So we should have this very clear.
Two things on this. When you're doing your rebuttal or your submission, please do not look at opposing counsel. only look at the tribunal. That's one thing. So your words are not directed to opposing counsel, they are directed to the tribunal. So with regards to your question, so if you want to pick up on a question that was asked by the arbitrators, there is divergence as well. So it's a maybe. Some arbitrators who actually like that, like, he's been paying attention. He picked up on something. We asked an opposing counsel, couldn't answer, and they made their rebuttal about them. And some arbitrator would be like, are you saying we're not impartial, that we're siding with you? That happens too. They'll be like, we just asked. Doesn't mean we align with one or the other. So it depends on who you have as an arbitrator. Some will like it, some won't.
Any additional? I know it's too late, so we want to finish also this. But is there any final comment or question? Okay, so then just to say it again, I please for all the coaches, please send your who are you facing in Vienna, because you're not allowed to see your opposing counsel in Vienna. So please make sure to send it to the administrators. And on behalf of Ghada, thank you so much, everyone. It's a long day, and I know you're some of you are you just arrived today. So go get some rest, and we will have another long day tomorrow. So inshallah, we'll see you all tomorrow. Thank you so much.